which can be used to provide checks and balances. And so some of the mechanisms in the Council of Europe is the European Court of Human Rights, which gives rulings on these articles of the Convention. And there's some really big cases coming up now regarding the right to privacy and mass surveillance, in particular one called Big Brother Watch. We have expert bodies which deal with constitutional issues, which have made reports. We have 47 group of 47 countries and their data protection authorities, which are looking at questions of privacy and certainly in the future on mass surveillance. We have an independent commissioner on human rights who's released 2 reports on these issues. And finally, I've left a few copies here. We have the Parliamentary Assembly, which looks at the question of parliamentary oversight of questions regarding human rights, and there's some very good work being done this year on mass surveillance. So all of that to say, we'll be watching this with great interest. Thank you for the invitation. There's a few events on mass surveillance over the next few days. We have the Council of Europe is organising an event with the OHCHR on the right to privacy in the digital age on the 11th of November from 4:30 to 5:30 in room 10. We have another event on internet freedom on the 13th of November, which involves questions of mass surveillance and privacy between 11 and 12:30 in room 6. And if I'm not mistaken, there's another event which I'm looking at the girl in front, which is also linked to mass surveillance, workshop 114, implementing core principles in the digital age, which will also touch upon the issues. That's in room 10, 11 to 12:30. I say that because there's probably 4 or 5 events this week in which, if you're interested in these things, these are the main areas, the main workshops to discuss these things. So thank you very much, and let's get on with the discussion. Thank you.
Before we do, I just would like to acknowledge the presence of Frank LaRue, former UN Special Rapporteur on the right to freedom of opinion and expression, and just quickly go over our agenda. Today we're going to have a brief panel that will highlight some of the key findings of this comparative research. Then we will have another panel devoted to the new challenges for data protection in the era of big data and mass surveillance, and finalize with the right to privacy in the context of mass surveillance. In the first panel, we'll have a keynote speaker, Stefano Rodata, and the second one, Joe Kanatachi. So let's go to the first panel, and I would like to call here Shamila Venturini, who is a researcher at the Center for Technology and Society, and Anya Dalman, who is a researcher from SWP. They will present the findings with us.
So, I will start, give you some insight into the German legislation and the German legal principles on data protection in general. Would take roughly 10 minutes to do that. And it will afterwards allow you to understand what is the German approach, which is a very specific one. It is well known, developed by the German history. So after two totalitarian systems in the last century, Germany is very sensitive to the problem of privacy and mass surveillance, and I'm going to show you how the concepts in the legal framework have been developed over time and still developing. So my first point is about the general legal principles, and they are basically laid down in the German Constitution. So we have Article 1, which is the inviolability of human dignity, which is a very important one when it comes to mass surveillance of foreign citizens, because there's the question if this is a value, a norm that isn't true for Germans and or even not for other citizens. But as the German Constitution says, it's about the dignity of human being and not about the dignity of human citizen of German citizens. So that's Article 1. Article 2 of the German Constitution is about the right to self-fulfillment, and that's a very important one because the right to self-fulfillment basically lays down the right to privacy. So that's the fundament of very important court ruling over the last 20-25 years in Germany. And there is a special ruling of the German Constitutional Court that's 25 years old now, and it's about the information self-fulfillment of the citizens. German citizens basically have the right to understand what happens with their data, and no one is able or is allowed to process the data without their allowance to do that. Of course, these fundamental rights in the German constitution can be restricted, and in the case of Germany, this is also laid down in laws. So there's supposed to be no unregulated restriction to the law based in the constitution. So we have two restrictions, two exemptions here. One is for law enforcement, and so that's basically for the police work. That's law enforcement and crime prevention, and the other restriction is for intelligence agencies. And for the latter one, there is a special law. It's called the G10 law, and I'm going into details on that later on. Which brings me to a basic principle in Germany. It's also a lesson from the German history. That is the distinction between police and intelligence agencies. So there's a law basically saying that the cooperation, except of case-by-case cases, that the cooperation is forbidden between these two institutions, police on the one hand, intelligence agency on the other hand, because they are working obviously with different methods. These two areas, police and intelligence agencies, are very, very well separated in Germany, and for both we have separate legislation. So just a few words about intelligence oversight, which is basically my last point here. I already told you that there is a special law that regulates everything that intelligence agencies do, and there's a special law that regulates how intelligence agencies are able to restrict some of the fundamental rights. And obviously, if you do that, you need some oversight, and there are two mechanisms, two instruments in Germany. The first one is the Parliamentarian Oversight Committee, PKGR in German. It's a very long word, and it's a committee that comes directly from the Parliament. It works in secrecy, and the intelligence agencies are to report to that committee on everything they do on a kind of general basis. The problem with that is the members of the committee can ask every question, they can go into every detail of the work of intelligence agencies, but they have to know what asking for. So as long as you don't know what are the projects of intelligence agencies, you don't know what to ask, and this is one of the basic limitations of the oversight of the parliament. The second instrument is the G10 Commission, and I have to go into details a little bit. The G10 means Article 10 of the German Constitution. And Article 10 of the German Constitution is the right to secrecy when it comes to communication. So your communication in general terms is always protected against every interference from the side of the state. But there's a special law, and that's the G10 law, that regulates how intelligence agencies can break with this secrecy. And if they do, they have to kind of apply for that. And the Commission that oversees this this breaking the law is the G10 Commission. It also works in secrecy. It is not a commission that is part of the parliament, but it is chosen by the parliament, and most of the people, most of the members of that commission are judges. Although it doesn't have any jurisdictional working methods. It's basically a group of people looking into the applications of intelligence agencies to break the telecommunication secrecy. So this is the Article 10, the Article 10 law and the G10 Commission. All these regulations are only for German citizens. That's the main thing here. We are not talking about, we don't have any specific rule, any specific law about foreign citizens. So the question is, which are the rights to foreign citizens or citizens that are in communication with German citizens, and which communication has been surveyed or is monitored. And that's an open question. That's the basic question that is discussed at the moment in Germany. And most of the lawyers in Germany tend to say that the fundamental rights, not only from the German Constitution, but from other international conventions, like the UN Charter, for example, or the European Human Rights Charter, they also apply for non-Germans. That means that intelligence agencies have to obey to that law, but that's contentious at the moment in the German government. So the fundamental question is, again, are there any laws or any legal norms that apply to surveillance when it comes to non-German citizens? Okay, I leave it with that. That was 9 minutes, I believe. And I hand over to Jamila, who's going to go into the details of the Brazilian legal system. Thank you.
Thank you, Marcel. Good afternoon, all. Thank you all for coming. I'll try to bring a quick summary of the Brazilian framework on data protection and privacy, and Marilia will complement talking about intelligence activities. I will invite you all to take a look at the study that we handed to you. It has much more details on everything that we are talking about right now. The first thing I would like to call your attention to is that Brazilian constitution is very recent. It dates back from 1988, while we were coming from a period of an authoritarian regime. So a lot of the legislations the right to privacy and data protection is basically regulated through sparse norms that it can be found in different legislation. The federal constitution protects privacy and inviolability of the home and communications as fundamental rights. And Brazil has also signed and ratified several international standards on human rights, the Universal Declaration on Human Rights, the International Covenant for Civil and Political Rights, and the American Convention on Human Rights are some of them that are incorporated to the domestic law. The Constitution predicts an important exception to the inviolability of communications, which is for wiretapping that may only occur if there is a court order and solely for the purposes of criminal prosecution. A specific act regulates this exception, the Telephone Interception Act. Only chiefs, and it determines that only chiefs of police and the public prosecutor's office may request telephone interception, and for that they must prove that evidence cannot be obtained by other means. Despite this law being aligned with international standards and the Human Rights Court's jurisprudence on wiretapping, Brazilian courts have interpreted it in a broader way. For instance, stating that interception may be renewed multiple times, while the law explicitly says that interceptions should last 15 days, which can be renewed by the same period, meaning another 15 days. So in some specific cases, the courts have ruled that this might be renewed several times if there is a complex case and some specific situations. Some scholars have pointed out that the disproportionate nature of these decisions, calling attention to the fact that the Constitution itself already limits the period for interception or for the exceptions to the confidentiality of communications, even in extreme cases such as the state of defense and state of siege, for instance, stating specific periods for these interceptions to occur. Brazil was also condemned at the Inter-American Court of Human Rights for having violated the right to privacy by monitoring private conversations of land activists in a case that was, they evaluated that it was illegal wiretapping, considering the Telephone Interception Act. The constitutional text has also raised some important debates regarding the reach of inviolability of communications, if it would apply only for telephone or every type of communication. There is an important debate regarding the access to stored data, and that's important for some things that we will discuss further. The interpretation that has prevailed in the Supreme Court is that stored data can be obtained through search and seizure warrants for both criminal and civil cases, while the Constitution talks about interception only for criminal cases. The justification for that is that the Constitution refers only to the transmission of data and not to stored data itself. So this is something that has been largely debated in Brazil. Some cases that we found out adopt this interpretation that data can be obtained through search and seizure warrants, but this is still an open debate. Regarding remedies, Brazilian law establishes civil and criminal penalties for the violation of privacy and confidentiality of communications. The Telephone Interception Act and other norms have specific provision for that. However, it is important to say that it is usually very difficult for most citizens to identify if their privacy has been violated or not, especially when we talk about telephone interception. So this case that I mentioned before in the Inter-American Court is one example that at the beginning they couldn't identify all the victims that were affected by these measures. Regarding data protection, Brazil does not have a unified framework to deal with data protection yet, and this has given some margin of discretion for private and public bodies when dealing with citizens' personal data. We have some interesting cases that we mentioned on the paper, and maybe we can discuss that later. But data protection is already regulated through sparse norms, such as the Consumer Protection Act. The Consumer Protection Act determines that the users have the right to access all registers that include information about their activities, to be notified in cases where the retention might take place without their consent, and to correct personal data stored in private companies' databases. Although these measures are usually applied to credit reporting, some scholars have suggested that the Consumer Protection Act can be interpreted broadly so as to ensure some principles of data protection would apply to other situations. Two relatively recent laws have introduced new provisions on the protection of personal data and privacy in Brazil. The Freedom of Information Act, which regulates access to information, established some rules on the processing of personal information by public bodies. It says that personal information retained in public databases are restricted to legally authorized public servants and the data subject for 100 years. Access can only be authorized if that's permitted by law or if there is consent from the data subject. It's important to highlight that the Act is limited to situations in which data protection conflicts with access to information and to activities of public bodies or publicly funded nonprofits. Also, the civil rights framework for the Internet in Brazil, the Marco Civil da Internet, that Marília has already mentioned, emerged as an alternative to legislative proposals aiming to criminalize certain practices on the Internet. It regulates important aspects of data protection, seeking to grant to Internet users a higher level of protection. And in that sense, it explicitly incorporated two internationally recognized principles of data protection: transparency and purpose. It also contains a clause stating that relevant Brazilian law will apply to entities that collect, store, and process logs, personal data, and communications if at least one of these actions occur in Brazil. With regards to the Marco Civil, it only applies to activities on the Internet, and it doesn't provide detailed information, a detailed definition on personal data, which we understand that leaves room for different and perhaps contradictory interpretations by the courts of this definition, since we don't have a definition, a personal data definition in any other rule right now. Together with the fact that it leaves to implementing regulations some important definitions, it is still to be seen how the Marco Civil da Internet will be applied and will be implemented in order to protect Internet users' rights. With regard to data protection, it's also important to highlight that although we don't have a unified framework yet in Brazil to deal with this subject, there are 3 bills being discussed in this moment. We will discuss this probably in the next session more. And the last point that I would like to comment with regard to the Brazilian framework is related to data retention. So the Marco Civil and other norms before that, for instance, the Law 12850 from 2013 on organized crime, had already predicted some measures on mandatory data retention. In Brazil, this is Marco Civil establishes that logs of access to connection logs and access to application logs should be retained by Internet services providers or application providers. Connection logs for the period of 1 year, if I'm not wrong, for the period of 1 year, and access to application logs for the period of 6 months. This has raised a lot of debates, especially after the approval of Marco Civil. But it is important to highlight that these mechanisms were already present in Brazilian legislation, and even through other types of agreements between the Public Prosecutor's Office and companies themselves directly. So this is a point we would like to highlight. It's still, especially considering that we don't have a data protection framework, how these logs that has to be retained going to be protected, what are the mechanisms, what are the safeguards, and etc. This is still to be discussed. I will leave to Marília to talk about intelligence services right now.
Be super quick so we can take a couple of questions before we move to the next panel. Well, the Brazilian intelligence system actually is very recent. The law that creates it dates back to 1999, and the system was created with the general purpose of preserving national sovereignty, democratic state, and preserving human dignity. If we think about a concept of intelligence, there is no unified global concept, but if we think about the different aspects of intelligence, such as intelligence as organization and the different bodies that compose intelligence, we do have laws in Brazil that detail how the intelligence system is composed, what are the organizations that are part of it, that should provide information. But we do not have in Brazil yet, and this is a problem that we have, a definition of intelligence as activity. So what are the procedures that need to be followed in order for this information to be obtained, analyzed, and transformed into intelligence, and that will be given to the executive for it to make policy decisions. So if we think about the Brazilian agency that coordinates the system of intelligence, there's a system of oversight that is similar to what is in place in Germany in terms of being an oversight that is carried out by the parliament, but there are several opinions that the system really needs to be modernized in order for it to be really effective of supervising on a day-to-day basis what the organization, what the agency is actually doing. I think it is important to highlight that the aforementioned law that created the intelligence system, it clearly says in its Article 3 that all intelligence activities need to be conducted with regard and respect with the Brazilian Constitution and fundamental rights and guarantees. And this means, for example, and this is interesting, that the ABIN, the Brazilian agency, cannot do wiretapping. It cannot oversight private communications because it is not one of the organizations that is allowed to do so by the telephone interception law. But in spite of that, there are very broad areas in which there is no regulation with regards to the activities of the Brazilian agency, and that includes, for instance, online monitoring. So we know that during the protests, the street protests that took place in Brazil in 2013, the agency monitored the use of Facebook, Twitter, and even WhatsApp communications in order to understand what would be the rate and the size of the protest, what would be the itinerary, and even to understand what would be the sources of funding that would be given to these people to get organized. So we don't have a clear framework that would discipline that, and this is something that we do need to look into. Just to conclude and open the floor for questions, I think that one important thing is that according to the Brazilian law and the provision that every citizen has access to, should have access to information about himself, every person can go to a bin and ask for a file about himself. So if a file exists, the agency needs to give this information to the person. But we also have in the Freedom of Information Act specific limitation on that is related to national security and to investigations that are ongoing investigations. So if the investigation is ongoing, probably the person would not have access to the file. And we show how this very diverse and widespread framework that is not unified, many times we have conflicting laws, or at least laws that do not communicate very well with each other, and that can, in the end, undermine some rights that are being guaranteed. So I think that one takeaway is that we do lack a national policy on security. It is said in the law that created the BIN that we would have a national policy on intelligence, but we do not have this policy yet for more than 20 years now, and the lack of this policy really creates a broad area and discretion for a BIN to act in Brazil. And I think that in Germany, if we can draw a comparison, you have much more clear limitations for your intelligence that they need to observe in order to carry out intelligence activities, and that certainly is something that helps to reinforce citizens' rights. Okay, we would like to, if you have any questions about anything that was presented here, we can take a couple of questions. We do need to be on time for the next panel, so we cannot take many questions, but if you have any questions, please feel free to ask. Otherwise, we will move on directly to the next panel. I don't see any questions. Okay, so let's move on to the next panel. The next panel will be moderated by Luca Belli, who is a researcher at the Center for Technology and Society of FGV, and I will ask Luca to come and compose the next session. Thank you.
Thank you, Maria. I will ask my distinguished panelists to come here. So, Professor Rodota, Luis de Salvador, and Professor Danilo Doneda, please. So thank you for being here and for being a lot. So we will have the pleasure now to have a keynote, to start with the keynote by Professor Stefano Rodotà, who is the former president of the Italian Data Protection Authority, is one of the most renowned jurists that are now in Italy. and he is also the father of the Italian Bill of Rights, Internet Bill of Rights that was presented this morning. So maybe you will also know something about this. On my left also there is Danilo Donede, who is a professor at the Rio de Janeiro State University, and who is also the father of the Brazilian data protection bill. And then we have on my right Luis de Salvador, that, as you can see, is the head of the audit department of the Spanish Data Protection Authority. We don't know if he is father, but we will discover it in his presentation. So, so we will start with Professor Rota. Thank you, Professor, for being here with us.
I know, I know that the subject of this workshop could be the net neutrality, yes, but I would like to make a reference to the problem of net neutrality, but after I do prefer to make reference to a very important evolution of data protection during the last year. So, Luca Belli quoted the Italian Declaration of Internet Rights passed by the Chamber of Deputies in Italy in a very strange way, because the chamber is very divided politically, and this a document approving this declaration was unanimously approved. A strange exception. Article 4 says every person has the right that the data he/she transmits and the receivers of the internet be not subject to discrimination, restrictions, or interference based upon the sender-recipient type of content of the data, the device used, application, or in general, the legitimate choice of individuals. Net neutrality means not to be discriminated against. Part 2 of the right to neutral access to internet in itself is a necessary condition for the effectiveness of the fundamental rights of the person. This is a consequence. If I am discriminated against, my fundamental rights are denied. Too simply, baby. What there is behind the discussion, in some cases furious discussion, on net neutrality? Because in the US, maybe you know that President Obama declared his preference and his support to net neutrality, but there were furious reactions. It's not a problem of discussion on principle. This conflict is grounded on economic interests. The problem is that telecoms are losing their business. You know, you use telecoms less and less. So they are trying to have a market where they are interested in providing services differentiated, so having the possibility to have consumers with much more money than others that can pay a faster, more secure internet. So you can see, and the problem is how economy can influence the development of internet. This is a big problem. As for that I go beyond the net neutrality, and I would like to stress what, in my mind, is the more important development in shaping the internet environment during the last year. A new actor is on the stage, courts. And I think that also the problems of net neutrality will be the court dealing with this kind of problem. So it's important to know how courts are now acting. Courts means tribunals everywhere in the world. Mainly in the last year, singular, European Union, United Kingdom, Canada. What happened? In May of the last year, the Court of Justice of the European Union, a supranational court covering 28 member states, has passed two important decisions. First of all, the decision Google versus Spain, well known because this decision has declared that individuals have a new right to be forgotten. It means not that their information must be cancelled by in the database, but it's a problem to index or not to index that some information. So if this information are not indexed, people cannot find them. The second decision is Digital Rights Ireland versus Ireland. In this case, the same court has declared invalid a European directive on data retention. You have heard something about data retention, and has been stressed how the way and the times of data retention can change the fundamental rights of the person. The court said that the directive did not respect the proportionality principle. They have the directive was according to director and according the idea of the court, the time for retention was too long. So, but this is the specific object of the decision. But behind this intervention, they are, first of all, the Charter of Fundamental Rights of European Union. There is a direct reference in the decision to this charter. This charter, in this very moment, had the same legal value of the treaties in Europe. So, this charter is part, if I can use this expression, part of the European Constitution. And the Court of Justice is now acting as a true constitutional court. It means that there is in the area of the European Union, 28 member states, a constitutional court in charge of give protection in this area. And there are two articles, 7 and 8 of the charter. But what is said in the first decision, Google versus Spain, there is a very important reference saying that, I quote, that the article on data protection override as a norm the economic interest of the operator of the search engine. You can see that there was a conflict of value. The value of fundamental right and the value of economic interest. For the first time, a court in Europe has made not a balance saying there are two interests to be balanced, they are paired. They are on the same situation. They said, no, when there is a conflict between fundamental rights and economic and business interests, the priority must be given to the fundamental rights. So, beyond the right to be forgotten, an important principle governing the internet. Second, the Digital Rights Ireland versus Ireland, that data protection, the reason why there was an excessive term for data retention, the reason was security. In this case, the same reference to Article 7 and 8 of the Charter, the same new balance between values, security and fundamental rights don't have the same legal status. Must, again, fundamental rights must have priority over security. You can see that this is very important. And we can, I look at the 5 minutes more, yes. It's very important because there is, you know, that against the idea that internet can be regulated, there is an assumption, realistic assumption. Internet is something having a global status. We don't have a government, global government. So you can have rules covering internet. And this, in general and in a very abstract way, we can see that this is a correct assumption. But, in fact, what happens? What happened? The decision on Google versus Spain covered 28 countries. After this decision, Canadian citizens asked the British Columbia Supreme Court, saying why Google gives a supplementary protection to the European and this protection is denied to us. And British Columbia said, yes, Google must give you the same protection affirmed by the European Court. There is not directly a ultra activity of the European decision, but in fact, this dialogue between two courts, not legislators, two courts dialogue, British Columbia said, yes, we extend to the Canadian the same right recognized to European citizens. And in this decision, there is a very important wording saying in the new dimension, there are decisions that there are no borders. They are in itself global. This is another point very important. But if you go through other decisions, you can discover two others decisions. One is very recent, the case Schramm, the case of a young Austrian citizen saying that the transfer of his information in the United States violated their fundamental rights, because in the United States there was no adequate protection. It means that in the United States, the same information that in Europe could not be accessed, for instance, by secret services, in the United States were accessed by the secret services, as the Snowden case are made apparent. So, in this case, you have in the Schramm case a very important indication, because safe harbor, this agreement between Europe and United States was a tool making possible the transfer from Europe to United States of personal information, and this problem was, this solution was very, very important for all U.S. enterprises. All data collected, for instance, by American Express in Europe, all data collected in Europe by Google could not be transferred or not in the United States. This decision has been truly revolutionary. Some 5 or 6 days ago, the Congress of the United States was facing with this problem. The European Commission is discussing this new problem. It considers it an obstacle to the free circulation of information as part of a global market. In this case, the reasons of the global market were challenged by an individual saying, I think that my personal fundamental rights must prevail over the business interest. And in this case, the same conclusion of the European Court. The last case, Vidal versus Google, a decision in the United Kingdom of on a specific case with two important implications. The widening of the notion of personal data and the widening of the notion of damage. It means that Google must pay damages in situation before not obliging to do that. So I conclude why this evolution is very important. First of all, courts' dialogue among them are the first attempt to have a global government of internet. Second, this government has decided to have a priority, fundamental rights, challenging the idea that security interest and economic interest must be the true and day-by-day rule on internet. Preserving in this way not only the fundamental rights of the individuals, but also internet as a civic arena, a place where people can play freely the democratic game. Thank you.
Thanks a lot, Professor Rodota, for this inspiring talk and also for highlighting the importance of fundamental rights as a prism from which we can see the internet, not the other prism probably. But now I would like to pass the floor to Luis de Salvador, who will present as some concrete evidence of what has been done by the Spanish Data Protection Authority, analyzing surveillance practices, and both governmental surveillance practices and also private sector surveillance practices. So thanks a lot, Luis, for being here, and the floor is yours.
Thank you very much, Luca. Thank you very much for your invitation to to be here. I took with me a very short presentation, and I would like to give you a very brief overview about privacy in Spain and the worries about the mass surveillance by the Spanish citizens. In a recent poll, 67% of the Spanish citizens were very worried about mass surveillance activities, and not only from the most evident after the news of the leaks from Edward Snowden, not only about NSA, but they were worrying about other foreign intelligence services that were collecting data from the Spanish citizens. But of course, they are worried about our own security services, our own police bodies that collect data, and appear other actors in this scenario. We have found a lot of private companies that try to collect data in a massive way. We had a problem in Spain that we were carrying out investigations, and we destroyed a file of a private company that was devoted to debtor searching that collected more than 30 million data from more than 30 million citizens of Spain. And this is not only a question then of security services. And we have another actors that try to make mass surveillance too. We have a problem, an independence movement in Spain that try to make a massive poll to collect data from every house in a region of Spain, and to give a picture of the political tendencies of all the people that we had to investigate, and to, of course, to eliminate such kind of file. The resources that have the security forces to collect data are important, but not are unlimited. They have to use they have to get access to national databases. National databases come from tax information, land registries, civil registries, and census, and so on, are another source of very important information for mass surveillance. There are other private actors that allow to the intelligence services or other actors to collect information. The most evident are the telecommunication companies or the internet companies. But now in this world, there are other companies that come here. For example, the suppliers. We have now the implementation of smart meters in each home in Spain. The smart meters has the capability to collect a lot of information from the citizens that comes directly to the suppliers. We have, for example, the certification authorities, the certification that implements the security PKI system in e-commerce. They collect information about all your activity. We have the problems now with the credit cards that allow contactless transactions. They collect allow to collect a lot of data of the citizens. And one of the most important problems is that the private companies try to collect a lot of more data with focus in profiling and targeting of the citizens with the purpose to sell advertising. And we have to deal with the technology tendencies, the big data, the open data, to give data of the public administrations to be processed by private companies, the e-government initiatives that give access to telecommunication operators and third parties to a lot of information, the cloud computing pressure that is over companies and even over citizens, and in general, every online services. And what happens now, that if at the beginning there was we can find an unrest of the people, when the people is so happy to share and to use online services, to share that data, and they become some angry even when the data protection authorities, when we start to fix limits to the users to use such data. Regarding the Spanish legal framework, we have law that restrict the mass surveillance and law that allows mass surveillance too. If I will start with the laws that restrict the mass surveillance, I can talk about Article 18 of our Constitution, the Constitution of 1978. It's so recent, Constitution 2, that protect the privacy and intimacy of our citizens. It was developed in our criminal law, and it was developed in our current privacy law. It's not only a question to have a privacy law. You have to have an administrative law that protects your rights. And the administrative law in Spain have peculiarities that make a big influence in our privacy law. The first one is that we have the duty to deal with all the complaints of the citizens. The Data Protection Authority in Spain gets 12,000 complaints per year from the citizens, and we have the duty, due to our administrative law, about to give a legal grounded answer and to investigate the 12,000 complaints. It means that our data protection agency has 200 people, mostly devoted to make such investigations. And another peculiarity is that our inspection bodies, we have the right to go to inspect the facilities of any private company or national body, to go to the facilities, to access the procedures, to get the papers, and to go into the computers and in the databases to get evidences. All the companies has such duty, and in case that we identify an infringement, we can fine directly to the companies between 900 euros fine to 600,000 euros per infringement, not in only one infringement. It means that we usually we fine an amount of 22 million euros per year. Another peculiarity is the development of a security framework in the development of the privacy law that is focused to protect not the system, but to protect the privacy of the citizens. And one of the provision in that security regulation is the obligation, the duty, to encrypt communications in case of sensitive data. It's not allowed to encrypt. It's a duty to do so. And of course, we have developed CCTV regulations to limit the capability that police forces and private natural persons to install and to process data from CCTV systems. Of course, on the other hand, we have some laws that allow the mass surveillance because we have a set of law, each specifically for each national database, from census to civil registry and so on. We have the law of police forces that allow, with some premises, to the police forces to collect data from the citizens. We have an identity card in Spain with how to say, it has a circuit, included a circuit in the card where we store the picture, the fingerprint, and the signature of each citizen. We have a data retention law that forces to the telecommunication companies to store at least during 1 year all the traffic data communication. We have the tax law, and now the money laundering law that allows to collect the data without the consent of the citizens regarding all the movement of money. And we have other laws, for example, National Registry about infectious disease and so on. I have to make a little stop in the case of intelligence services. We don't have in Spain from the Data Protection Authority the capability to inspection over classifying information. Classifying information is not the same like intelligence services. You can have classified information, for example, in the Ministry of External Affairs, on other national bodies. And not all information that is handled by the intelligence services is classified. There are rules to classify information. If it's, you don't follow that rule, this is not classified information, and we have the competency to do so. And it's so limited the amount of information that could be classified. On the other hand, we carry out several enforcement actions over mass surveillance files. I try to order such enforcement actions from files from security forces to poor private collection of data from the citizens. But it's difficult to fix what is exactly the border. Of course, we made it on the files of the security forces. We have the duty to make investigation in the Schengen information system that collect data from foreigners, and to be sure that they collect such kind of data with the limits of the law in the Sirene offices and in the visa information system. We made inspections in the criminal records to guarantee that the information is up to date and to raise all information. We make a periodic inspection to the identification files of the police. The police have the right to identify you in the street and to collect your data, but they cannot collect all the data. They have to tabulate all the topics that can use the police to get the data. They have to erase the data and to apply criteria to restrict the access and the retention policy of that data. In these cases, we have investigated the national identification document files that store even, I told you, biometrical data. And for example, the files that collect the police regarding the API information from the transport companies, and the files that they get the police from the guest registration in the hotels. For us, it's so important to go into the system, not to ask to the police information, but to go directly into the system to get access to the data store, and to start to make an audit and to ask why that people or that person has been included in such files. We have made inspections, of course, in the census. The census must be audited every 5 years by the Data Protection Agency, into the civil registry, into the land registry, and in a very important registry that is the road traffic registry of the traffic police. Such files contains a lot of information, and we are very interested in that information is accessed only for the people that has a real interest, a real right to access to that information. Of course, we made inspections in the data retention and phone tapping system. In Spain, the access to the data retention, the data kept by the telecommunication companies, and the phone tapping could be only done with an order of the Court of Justice. The order of Court of Justice must go directly to the telecommunication operators, and the telecommunication operators in such case can give access to the police in role of the judicial police. Our duty is to inspect that system is working, and there is no any phone tapping or disclosure of information from the telecommunication operators to the police or to security intelligence services without a court of justice, and to control that court of justice order exists and they are correct. Of course, we have making inspections in CCTV systems, because we are now so worried not only about the common CCTV systems, but those CCTV systems that get a profile of the person, detecting the movements and classify that person like a criminal or not, that try to be put in force in the airport, and now it's forbidden, or the CCTV systems that are now included in the drones that are buying the police to control demonstrations and so on. Of course, we made inspections in the API and PNR systems and the disclosure of such kind of information to United States authorities and other authorities. We are carrying out a very important investigation regarding the cookies and other technologies that allows to the sites to collect information, and more important, a kind of super cookies that are included in the mobile system when you access with the mobile to a web service. When you access through the mobile, the data could be collected not only from the website, but from the telecommunication operators that includes a super cookie. And we are making such investigation in the telecommunications operators in Spain. Of course, we have the affairs of Google and Facebook, and the affair of cloud computing, because I think that a part of the right to be forgotten, I think that you know that we fined Google with 900,000 euros of fine. It's not so much for Google, but the important is that we are on Google to get information about how they are processing the data of Spanish citizens, and to allow the Spanish citizens more control about the data that Google is collecting from them. And in cloud computing, there are very complicated situations because, for example, in Spain, a lot of education institutions use websites that give access to fathers and to children to activities online. And behind these activities, there are e-books. And behind the e-books are the editors of the e-books. And every activity that our children does is recorded by the editors of the e-books, where my children stop, where my children had some difficulty to respond the answers of the book, and so on. And we are doing a lot of new challenges. The right to be forgotten, because it must be developed, the down-hole traffic control, the profiling in digital signage, the problem of other activities like thermometrics, Internet of Things, smart meters, e-health, engineering in social networks, safe harbor, and so on. And finally, I want to give a short overview. Because I have so few time, I will choose only this transparency. This is a graphic about, you know that we had a big problem in Spain with the terrorism of a terrorist organization called ITA. This is the graphic of the people killed by ITA from 1968 to 2010. Our first privacy law was in 1993. Our second privacy law was in 1999. The additional regulation of security measures about privacy was in 2007. We increased the legal rights of our citizens to privacy, and in the same way, I think that we, the security forces, had the tools to fight the terrorism. There is a need to cut the rights of the citizens to get more security. We now have more security in Spain with more privacy and less terrorism in the same period of time. There is no direct correlation between loss of privacy and gain of security. Thank you very much. I'm stop here.
Thank you very much, Luis, for providing us such a comprehensive overview of the Spanish system, and also for reminding us that it is not enough to have good laws. It is also necessary to have good authorities that implement the laws with appropriate resources. And now I would like to ask to Danilo to provide us an overview of the Brazilian system, but not only what is already in place, but what could probably be in place in the nearest future. And Danilo, you are probably the best person that can provide such an overview. Thank you.
Thank you very much, Luca. I will take profit of the work done by Jamila on describing our current situation regarding privacy and data protection. And I will talk a bit about some legislation that actually lacks Brazilian legal framework regarding privacy and data protection. We all know that Marco Civil, the Brazilian Internet Bills of Rights, regarding to privacy and data protection, did a good job on following the example of the Charter of Fundamental Rights of European Union, on stating that in its principles, between the principles for the use of internet in Brazil, we can find two principles: the principle of privacy protection and the principle of the protection of personal data. That division dates back to the work done by Professor Spiro Simitis, Professor Stefano Rodotà, who was with us until 5 minutes ago, when drafting the European Bill of Rights on this very point. And it's very interesting because it forces us to think that data protections is a separate, is an autonomous issues, and by protecting personal data, we can protect not only privacy, but the liberty of people, of the citizens in the information society. So we can protect people against discrimination, we can protect people's free will, we can protect the personal sphere, we can protect a series of rights that only becomes bigger when the personal information is used for more and more every now and then. Okay, but when providing that privacy and data protection particularly is a principle of internet use in Brazil, Marco Civil says that data must be protected according to the law. The question is, which law? We have law regarding data protection. We don't have a general law about data protection. Yes, we in Brazil have the Constitution, we have the Code of Consumer Protection, we have several statutes that Jamila has announced us. But Brazil is also one of the few big economies in the world without a general data protection law, which is a law that protects personal data in every sector, in any occasion. Much has been done in Brazil regarding data protection by means of the consumer law. And the consumer law has done a good job on protecting personal data in credit databases. But what we see in the last 5 to 10 years is an ever-growing increase on the causes of, for instance, bank fraud, personal data abuse in general, data leakage. Several scandals happens with regard to personal data. We can count that every 3 months we have a new scandal. We have I cannot count, but it's kind of a rule in Brazil that every year we will have 4 to 5 big scandals. And apart from the concerns of citizens against the misuse of their personal data, there's also the private sector that needs clear and even strong rules to protect their usage of personal data. They need to know, the private sector, of course, needs to have clear rules to make sure that their treatment of personal data won't make them liable for some circumstances they cannot guess what they are right now in Brazil. And there's also the point of view of the state, the public manager, the public servant who is responsible for public databases is even more concerned about his personal liability regarding the databases he is responsible about. So we see right now a situation in Brazil is focused on trying to choose a way to regulate personal data. And why Brazil haven't until now regulated personal data protection? If you can make a kind of geopolitical map of data protection, we can notice that only in Latin America, all the countries with economy comparable in size to Brazil have their own personal data statutes enacted. Argentina, Colombia, Peru, Mexico, Uruguay, and several others all have their general personal data protection. Why? What is the reason of the Brazilian exceptionalism? I've heard, I don't know, for many people, some serious people, that this could be due to some public nature of Brazilian people that would be presumably expensive and cool about sharing their data. With all due respect to this opinion, those assumptions are not only unfactual, but reveals general prejudice about a kind of stereotypical Brazilian that cannot be taken seriously, in my opinion. Brazilians are concerned about, as much as everyone else in the world, about disclosing their personal data. They are concerned about the means they must have to control their own personal data. People care about their personal data. Maybe Brazilians were just taught not to worry about this. They are taught to trust people who treat their personal data, but anyway, reality is doing a good job in constantly changing people's perceptions about privacy. You can see, for me, for instance, I noticed that for sure last year when there was a contract regarding our electoral court and a company who does big data, when the court gave would be given databases including biometrical personal data from millions of Brazilians to this company without much explanation. And public opinion was very against it. The press standard the situation with a bit of seriousness. So we believe that in this situation, and also take into account that in the last 10 to 15 years, more or less 40 million people arose from poverty in Brazil to the formal workforce and to the middle classes, it must be taken into account that privacy was not the first concern for all these people, but it's slowly but constantly becoming one concern when they began to use from public services who uses personal data to social networks, and they begin to see the effects of their data being breached. In this sense, we must say that, okay, Marco Civil isn't a data protection law. Consumer law is not able to protect personal data in its entirety in Brazil. What can be done in terms of framework for data protection? Currently, as Jamila has already said, we have three proposals, two in the Parliament and one which was made public by the Minister of Justice last month. All the three proposals, interestingly, have the same cultural roots. All three are based on the same text, which was the basis of a public consultation made by Minister of Justice in 2010. That's interesting because it makes us feel comfortable with the idea that Brazil has a kind of already chosen legal framework to regulate data privacy based on principles, based on the idea of a strong authority. Yeah, okay, based on some principles which are traditional, but at the same time, after the last public consultation, which was made on the first semester of this year, the last version of the bill, the draft bill, was adopted, and it included several provisions that adapted the law to the Brazilian legal general framework. In this way, the draft bill insisted in unifying the tradition that started with the Marco Civil of Internet, of running a public consultation, but even went beyond, because for drafting the last version, the Minister of Justice used analytic tools developed ad hoc by CWeb from the Brazilian Internet Steering Committee and the Federal University of Minas Gerais. Their analytic system is a way that is meant to improve the process of public consultation analytics and also of rulemaking in Brazil. The final text has no winners. I believe that several of the stakeholders which participated in the public consultation were represented in the final version. It combined, as I said, traditional data protection instruments with the strong Brazilian legal tradition of protecting citizens, which is very strong in Brazilian consumer law, but also included some other instruments, some instruments that are being debated, for instance, in the forthcoming regulation of data protection in the European Union. This text and the path that Brazil will follow on regulating data protection will be very important, because in the sense that on the external point of view, choice of Brazil on regulating data protection would be very important on balance of the global data protection framework, in the sense that Brazil is most probably, of the big economies which don't have data protection enacted, the one which is more close to have this kind of legislation. And in the absence of a document such as an international treaty on data protection, or at least at some points of data protection, it is very important to look for the balance between the current legislations in the world. Brazil, opting for a strong data protection framework, can influence other Latin American countries and even count very consistently on the balance of the global panorama of data protection laws. I believe Brazil is a kind of last frontier from the first phase of data protection legislation, or at least in the Western world. And it's very important that the next choices Brazil made are in hand with protecting citizens in society of information. And as we were talking in the Internet Governance Forum, is very important because the the data protection regulation will be a necessary complement to the Marco Civil, in the sense that the very Marco Civil provided for calling for a special law, a general law on data protection. Take a look.
Very much, Danilo, for this inspiring thoughts. And I would like now to open the floor for questions, comments. I'm sure there will be many. So please, if you have any questions or comments, it's your time. Do we have a roaming mic there? Thank you.
Hello. Is this on? Hello? Okay. Yeah, hi. I'm from the University of Washington. My name's Dan Arado. I'm doing research on the Marco Civil and the implementation of it. And you talk a lot about the possibility of the data protection law and the different aspects of it. But I'm curious what your attitude is about it actually passing in the near-term future, because there seems to be a lot of cynicism in the country about the Congress being able to control, or at least the president being able to control the Congress to such an extent that you would pass a law. And for instance, with the Marco Civil, it took a number of very specific political circumstances to enable it to pass. So I'm wondering if you could give me your thoughts on the possibility of it passing, I would say within the next year, perhaps, but I don't know if that's optimistic or not.
Perhaps, Danilo, you can directly reply to this, then we can take other questions.
Okay. But as a political analyst, I'm not even a freelancer, that is, I cannot guess what's going to happen. But you're very right on saying that it's quite impossible to predict what's going to happen. We have a particular situation in Parliament, but the thought we have that when working on the draft bill was that anyway, we cannot wait any longer. We have a bill on the Senate which can become our data protection law. If the government remains quite silent, it will become one day. So regardless of thinking what's going to happen in Parliament, the idea of the Minister of Justice was to make public this version in order to be sent to Congress, worked on Congress. And one very interesting point that we felt in the last months is that even if the other bill which is running on the Senate is a data protection bill led by the opposition to the government, even the senator who is working from that law, who is senator of the opposition, of course, he's seeing the data protection subject as a state interest, not a partisan interest. So until now, it's not to say I'm optimistic. It's difficult to be optimistic in Brazil because of many factors. But at least the question of personal data until now is being seen politically as a state-level question, not a partisan question. But anyway, of course, when the bill comes to the Congress, many hidden interests may arouse, and what must be done is that the civil society, the government, and all the stakeholders of people interested in a good and strong data protection bill unify their forces to make any advances, any rights presented on the bill being enacted when the law is finished.
Do we have any other questions? Oh, I think there is a question. No, there is no question. So thanks a lot for staying here. We now have a short break, and then we will come back with our last panel with a keynote by UN Privacy Rapporteur Mr. Joe Kanatachi and other very, very inspiring talks. Thank you.
ability to have so few time to talk, because I like it to talk more about our experience in enforcement. Because we have a lot of experience in enforcement. Because I know that the inspections I told you I made them by my own, because they were so complicated, of course. Just because when you go to a police authority and you start to say you cannot do this, I have no access to hopefully the service where you have access to how who has we got access to the police you don't make
Oh, it's him. No, it's him. This is the slides. Do it. I appreciate it. Hello, welcome back everybody to the last session of today. And well, as you probably know, my name is Lee Hibbard. I'm moderating this session. We have a great panel here, and I think as moderator, I'm going to try to do it a little bit differently. I think we're going to try to have a dialogue with you, most importantly, rather than a monologue. We're here because we want to dialogue. We want to talk together about the concerns that you have, about concerns on mass surveillance and privacy. So we really would like a discussion rather than just presentations. I'm going to, before going to Joe Kanatachi, who is the new UN Special Rapporteur on the right to privacy in the digital age, and for his opening keynote, I'd just like to quickly introduce Anna Vistelli from Netzpolitik, who is going to speak. We have Harry Halpin from W3C, who is going to, I guess, give his personal views on this. And we have Danny O'Brien from the Electronic Frontier Foundation. They are all, I know, passionate speakers, and they're going to come into your, I think they're going to respond to some of the dialogue that you have. We're going to have a really, hopefully, a very good discussion. Before we get going, I'd like to ask the people in the room, who are you, where are you from? Are you from, what's the makeup of the audience? It's very important for us to know who you are. Is anybody here from national security institutions, agencies? And are there any hands there? I guess there are no hands there, but would you tell us if you were? I guess not. Is there anybody from law enforcement here? Put your hands up. At least half a hand? No? Okay. Okay, now, is there anybody from government here, representing the government? 1, 2, 3, 4. Oh, good. Now I know who you are. Thank you very much. You might need to come into discussions. But of course, you don't have to speak for the other stakeholder groups that I've just mentioned. And I mean, are there any people from technical community here? From different parts of the technical community? I can see no, one. Okay, thank you. It's good to know. Academia? Okay, 1, 2, 3, 4, 5. Okay, that's good. Academia. And then civil society more generally. That would probably be the whole room, wouldn't it? Okay, and that's great. So at least we know who we're dealing with.
I also like to think the national security apparatus are here in spirit, in that they're probably. I'm talking into a microphone, so I imagine there's some record being made.
Okay, so thank you for that. Right, let's get going. This panel should work on its own without me. So I'm going to pass the floor straight away to Joe Kanatachi, again, the new UN Special Rapporteur on the right to privacy in the digital age. It's exciting. I don't know whether this one is one of your first engagements, Joe. I don't know, but you'll tell us. Perhaps you can tell us also, in the context of your presentation, how you became the Special Rapporteur. I mean, what was the momentum for that new post, and perhaps some of your vision for the next years. Thank you.
Okay, well, that's a completely different presentation to the one I prepared. But who cares? Good afternoon, everybody. If you don't mind, I'm just going to walk around. You know, this is supposed to be the land of samba, but I don't think I could samba, for, you know, to save my life. But it's good to be here. It is, I don't know, if it's certainly my third or fourth speech of the day, and I think that this week is going to continue to shell out that way if my schedule is anything to go by. Frankly, why after 35 years of working in the field did I get to be made Special Rapporteur? I don't know, you know, I think part of the truth is that I belong to the club which goes by, you don't have to be crazy to work here, but it helps. And it's actually part of what we have been up to. I mean, we have been trying to work on various areas of privacy and data protection for the past 35 years. I mean, I started off at the Council of Europe 30 years ago with the recommendation on data protection and the police. What I wanted to do, though, actually, in my presentation today, Lee, I'll get back to some of the questions you asked later during the Q&A, if that's okay. I wanted to get people to think about why some of the questions need research, right? I'm actually, when I was thinking about what to prepare about today, I thought, listen, more than likely, and I think Lee has just proved it, I'm going to be preaching to the converted. And that's not good. Why? One, I wasn't cut out to be a preacher. Two, you're all converted. I mean, you know, no NSA, I mean, I don't know, perhaps some of us might have some hacking team software sitting on our machines, you never know. Certainly the FBI have been paying for it, and a few other police forces have been paying for it. But I thought it would be interesting for us to reflect why we need solid research about the subject. Because when we go to our policymakers, if we really want to affect change, we need evidence, right? So I thought I'd burn a few slides on evidence-based research, and also while we're at it, comment a bit. I've got many slides, most of them more designed to answer questions just in case you ask them. And I know Lee's a bit like me, you know. What's the polite way, Lee, of describing a pain in the ass? Yeah, pain in the ass, there you are. So if I won't ask the awkward questions, he will. So that's why I suspect he said the parallel will roll along on its own. Let me talk a bit about why we do need research-based. I wanted to look at some of the methodology we've been using, because actually when people ask me, so Joe, how do you propose to do the job of the UN Special Rapporteur? And I say, well, basically we've been gathering evidence for the past so many years. I mean, at this moment in time, I have a team of 20 people in the Netherlands and 10 people in Malta, and altogether, I guess we're doing something like over 40 million euro worth of funded projects, all of them dealing with security and privacy, and we have built up quite a stock of evidence about the different areas that we're talking about. So one of the latest things to hit us, which is an interesting complication, is the discussions between the United States and China. Now, please think about the very simple fact that when you have fiber optic cables, and I am old enough to have seen most of internet data traffic shift from satellites to fiber optic cable, we have everything going through fiber optic cable. And that is one of our biggest issues at this moment in time. It all goes through the same cable. Comms goes through the same cable. Internet chatter goes through the same cable. And cyber war and cyber espionage go through the same cables. And when we fix, or when SIG-INT people fix their little boxes in Sigonella and Sicily, in places in Spain, places in Cornwall in the UK, actually they tend to use the same boxes and the same kind of software for a lot of things and then change the selectors. I'm simplifying, certainly, ladies and gentlemen, but what I'm trying to put across to you is that it's rather easy to get, and no puns intended because it's all fiber optic anyway, but it's rather easy to get your wires crossed when you're talking about cyber espionage and cyber security and cyber defense, because people will use the same excuse to try to get to this. And if you notice, when we got some of the news communiques about the US and China, what we got is the beginning of some understanding about attacks on critical infrastructure, but we didn't get any agreement about cyber espionage. So they're still very shy about that, right? However, I'm not faulting Obama and Xi for talking about it. And if you notice, what Obama said is, what we're hoping is that we can get the beginning of something going, and then people to coalesce about it. And why do I want to use that as an example today? Because that's exactly how international law takes place. That although you would like to have the maximum number of people agreeing to the maximum number of principles in the shortest possible time, nobody's so much of a fool as to think that's going to happen overnight, right? But at least you start. You don't keep telling yourself, I won't start because it's going to be a long road or we'll never get there. I mean, if we had to look at one of my favorite examples here is copyright, you know, because people keep telling me, oh, but the United States will never agree to this. You know, hell, it took more than 100 years to get them to agree on copyright, but we got there finally, right? So when you're looking at technology and the way it tackles things, I'm actually very pleased to see some of the latest developments taking place, and I'll get back to those in a minute. The Snoopers Charter in the UK is, of course, just a bit more, it's just a bit worse than scary, isn't it? I don't have the time to go into the draft bill that was published on Wednesday, right? But I think, and I think that this will come out in some of my public comments over the next week, one of the most misleading comments that has been made in the UK Parliament this week, last week, I'm sorry, got the wrong week, is the one which said, we don't really have to worry about it. Because all we're doing is, we are giving our secret services and our police the same powers that they have today over the telephone. Which sounds okay at first sight, doesn't it, at first hearing? But it's not. And it's not because it takes the issue completely out of context. And the context is this. When we gave the police and the secret services the right to intercept, and remember, some governments were dragged kicking and screaming into that, the UK being one of them. The UK's Interception of Communications Act only came after Malone versus Commissioner of Police in 1985 in front of the European Court of Human Rights. And RIPA and the UK law only came post factum, 40 or 50 years after the secret services were actually set up. So it's not as if the people set out with a plan to be law-abiding and have maximum oversight and then came in and did something about it. No, but what we're talking about here is the context, and the context is completely different. When those laws were put into place, there was no internet, or the internet was not used in the way it is today. Today, each and every one of you and me creates tons of metadata which simply did not exist, and that is the context, ladies and gentlemen. If you're really working in intelligence, all the talk about the world going dark is just that, talk. And if you look at what previous heads of US intelligence and defense agency personnel have said, they have openly admitted that they don't need back doors. They don't need to engineer back doors. They don't need some of the measures which are being requested. And this is what's scary about emerging from what Peter Swire has called the golden age of surveillance. It is the golden age of surveillance. They've never had so much data. Never. And I'm just talking about the metadata. I haven't got down the content. In fact, Peter Swire and many others, including a number of ex-generals and ex-heads of secret services, argue you don't even need the content. You can actually use the metadata to such an extent that you then go to the much more secure ways of normal infiltration. Apart from the very methodology has been criticized, right? If I look at one of the authors of the latest reviews in the UK, Professor Michael Clark said rapid legislation was not a good idea. So it's not only the content of what they want to do, but even the way they want to do it. Is this a democracy, ladies and gentlemen? And I'm here quoting Professor Clark, but I'm not disagreeing with him. We've got to have a proper public debate about this, which should go on for at least 18 months or 2 years. If government tries to rush through a bill in the autumn without real public discussion, they'll run into all the same problems they had in 2014. I think I'm now going to stop. I'm going to lose count of how many times I've talked about the United Kingdom's efforts in the field. This started off as something called the Interception Modernization Program, and I wrote about it. And then they did it something else, and I wrote about it. And we've gone from one fiasco to another. And I don't have the time, but I could go into demonstration of why the way that some of the actual effects on temper, etc., bypassed the British democratic system, and bypassed oversight in the UK Parliament. But, we're now at the stage where the first time we have an absolute offensive. Just do a media analysis, ladies and gentlemen. Do a media analysis of the way that the British establishment, the UK establishment, is trotting out news about the law and the need for the law. And ask yourself the question, if this is not orchestrated, what is? And have you ever seen anybody happier than finally having, the head of MI5 there speak on the media? I mean, we are at the stage where they realize they're onto something. They realize that they have to bring out all the big guns to talk about it. But where are they going? But I'm not here to talk about the UK. The UK is just flavor of the week for now. France has brought in a law on to me, what seemed to be the emotive wave of Charlie Hebdo, and yet defying all logic. Nothing in that law would have prevented Charlie Hebdo. When you look at the facts of Charlie Hebdo, it would have not prevented it in the same way as the Boston bombings were not prevented. In fact, those two cases follow such a pattern of people known to the security services, people who could be a risk, people whom the security services let go because they said they don't have enough money to have enough agents following enough people. I don't know. I just do my sums a bit simply, ladies and gentlemen. I tend to say spend less money on your computers and spend more money on human beings doing real intelligence work. Because the tendency we seem to have is I can, therefore I will, so I'm going to get my electronics eavesdropping out. And yet this is where I keep referring people to the report by the Dutch intelligence services called Jihadism on the Web, where if you read carefully, both between the lines and explicitly, they're saying this is not the way to do it. Through mass surveillance of this sort, we're only going to catch the most stupid terrorists, if at all. And to get the real terrorists, we have to infiltrate the cells. We have to go for good old-fashioned infiltration. And when you look at the evidence we have found of the way that terrorists are using the dark web, that's the way they're using it. If you look at an analysis of all the algorithms for encryption which are being used by Al-Qaeda, ISIS, and other terrorist groups, it's clear. You're not going to get them by intercepting Lee Hibbard's and Joe Kanatachi's emails. That's not the way you're going to get them. You don't even get the most basic of people, like the Charlie Hebdo people or the London bombers that way. You don't get. So it's time to be realistic and actually examine what we need and what the evidence shows. And I would be the first to vote money and effort for anything which protects the right to my life. But in this case, I would like to live in a society worth living in, and not in a society where disproportionate means are being used to follow me around electronically without sufficient cause. And at least in the UK, there's an open debate. I don't have the time to go into it, but there are a number of countries, some of them represented in this room, which actually have a far more serious situation, which actually are in the region of 10 million unauthorized interceptions and more every year. And is this the kind of society you want to live in, ladies and gentlemen? No. And if not, then please give me the evidence, right? I could go on over here, but I just wanted to stop for a minute and talk about why windsurf is wrong. Windsurf went on the record last year saying, and I'm going to read this: privacy may actually be an anomaly, right? Privacy is a construct of the modern industrial age. In the past, his thinking goes, people lived in small, self-contained villages, where pretty much everyone knew who was dating the baker's daughter and what the sheriff had for lunch. It is only when populations started migrating en masse to cities that anonymity emerged as a byproduct of urbanization. Okay, now I'm not going to do a plug here, but I'm short on time, right? But if you want to know why what windsurf is saying is pure undiluted rubbish, then please go to my last book. It's referred to in the introduction, and you'll understand that privacy has been around for something like the last 30,000 or 40,000 years. I've charted it there, and if anybody sends me windsurf's address, I'll send them a copy of my book for free. The reason is this is most unpretentious, ladies and gentlemen. Don't get me wrong. I'm saying this very modestly. I cannot understand how a person of the intelligence of windsurf, whom I've respected for so long, could say anything so dumb. It's just dumb, ladies and gentlemen, that you just show yourself to be ignorant of the way that the Aboriginals have lived, of the way their information ethics and privacy have developed over the past 30,000 years. You go down all the space of history, you look at the Chinese, look at the Japanese, look at everybody else on the planet, even look at the Americans if you wish, and you arrive at that conclusion. I'm sorry, we just have to call a spade, and it's time we start doing something sensible about the matter. Which is why, for the Chinese, of course, 2014 was the year of the horse. But for me, 2014 was the year of encryption. I'm not Chinese, and I like to look at the things that I'm interested in. So just think about it. And we know that the stories are much deeper here, right? But we have Google and Yahoo working together on encrypted email. We have Apple defying the FBI and offering encryption by default on the new operating system. And stop for a minute, ladies and gentlemen. What is the new UK law going to mean for people like Apple? And a number of other large US firms. Have you looked carefully at the new UK law if it goes through in the way it's currently drafted? It means that they are repeating or making more explicit the powers they already claim for themselves in the current RIPA 1994. And it means that they are expecting to be able to coerce companies into helping them facilitate certain things, which can be construed in the widest way possible. That's one of the things which makes it scariest. And we should take that into account, because when we look at what, at the way that companies in the same way are turning privacy into a unique selling proposition, right? So I've taken that off the Apple side. We've built privacy into the things you use every day. This comes from the very company which 3 years ago, was being lambasted because it was sending data about its users surreptitiously back to the company. And you thought that you wouldn't live to see change? Today, these people are the biggest advocates for privacy, and Tim Cook goes around claiming to be a privacy advocate. I am not knocking that. I haven't met the man. He could well be, for all I know. But, hey, it doesn't hurt that Apple is now seen to be privacy friendly, does it? And I'm not being ironical here. I am assured that Apple products in China are identical to the ones sold in the United States. And some people have openly queried, would the Chinese ever let Apple operate without backdoors? It could perfectly be that that's the case now. What's going to happen in the future? I don't know. But have you seen the last proposals for laws in China, ladies and gentlemen? Where they are now talking about social credit being allocated to a person after his or her behavior is monitored, literally like the song from the Police, you know, every step you take, every breath you make, I'll be watching you. It is supposed to be an optional system. Yeah, right. I don't know what's going to happen there. I'm just going to finish on these couple of notes. Microsoft just made a huge privacy note to make Bing. Look what's happening, ladies and gentlemen, 2014. Privacy becomes flavor of the month. We try to use it to sell our products, to try to convince our customers to stay with us. And then David Kay, who's here present, but whose views I completely endorse on the subject, last May launched a robust defense on online anonymity and encryption. I'll skip those slides. And how am I on time, Lee? Am I just on the 15-minute mark? Nearly? Okay, I'll just tell you about some of the stuff we've been working on and stop there. Yeah, massively integrated multiple sensor installation. For the past 5 years or more, some of my people, some of my team in the Netherlands and myself and in Malta have been working on this. Essentially, you know, when it comes to CCTV, it doesn't really matter whether it looks like this or like this or like that. And that's why I've deliberately chosen a lampshade in the Cotswolds in the posh part of the UK and a lamppost in Beijing in China, because they're all carrying the same kind of technology. And sometimes the police does give the game away. It marks its van as conspicuously as this. Thank you. That helps. It's useless, spending hours finding nice pictures and then the luminosity is spoiled. But it's when we start linking the video from the CCTV and putting it and hooking it up to audio from microphones in and around the ground. And now we have microphones in a number of European forests, and plans to have microphones in other places, and microphones in a number of European towns, ladies and gentlemen. Today in the Netherlands we have microphones in some towns which are capable of zooming in on not me but Lee, because I would be walking along and if I'm laughing, it doesn't matter. But if Lee goes along and starts shouting at somebody because they're late in their PowerPoint presentation, that's a sign of aggression. Camera pans, tilts and zoom onto Lee. That technology has been around for years now. Only it's being made more use of. And then if you start linking all the sensors for detection of radiation, explosive, gunshot, etc., you can have sensors for potassium, sensors for bombs, sensors which can tell you if there's a bomb at 50 meters, so on and so forth. You take those sensors, you put them together, you link them up with several databases, you put them into a control room, you get MIMSI. And of course, for those of you who, like myself, carry one or more mobile phones, geolocation is what then brings it all together. And once you've put all that together, do you have science fiction? No, you don't have science fiction. You have Chicago, you have New York, you have London, you have Beijing, you have Shenzhen, and the list of cities goes on and on, ladies and gentlemen. We've started there about 7 years ago, and it's going on. And if this is the kind of city you want to live in, fine by me. If it's a choice that citizens consciously make, fine by me. But all the research we're sitting on, and that is why I started talking about evidence-based policy making, all the research we're sitting on suggests that citizens don't want this. All the research we're sitting on, and I have a list of projects here which goes on and on. We have over the past 5 years, 6 years, carried out tens of thousands of online interviews, thousands of face-to-face interviews, hundreds of focus groups, and they all suggest the same thing, that people still care about privacy. So if they care about privacy, and if there is no real hard evidence that mass surveillance is bringing in the results that are being claimed for it, why are we seeing laws rushed through or proposed in so many European and non-European places? With those remarks, I'm going to stop there for now. I've got plenty of more slides, but when you ask the right question, I'll come out and give you some form of an answer. The real answer that Lee is after, which is, what are my plans for the future? You'll have to come to the rest of the sessions in this IGF, Lee.
Very much, Joe. Thank you for your keynote. Very good. And I think I know from your slides what the plans are for the future. I've very kindly agreeing with the panelists that we're going to turn to you. I know some of you in the audience. I'm not going to pick you out, but I would really like that you take part in this discussion. It's your session. I hope that Joe has triggered your imagination and your views. I want to have your views, perhaps to Joe now. And I'm looking at you as I speak, and I'd like to bring in the panelists too, and they will come in accordingly on different points. But my question, I guess, to all of you, I think, why we have a full room? I think we're all concerned by mass surveillance. I guess if there's a lot of academic and civil society in this room, it's because they're concerned about mass surveillance. So, mass surveillance is alive and well, Joe. That's what you're saying, really, isn't it? So,
what I'm saying specifically is, and I won't mince my words, is that many governments at this moment in time are putting in new laws to legitimize that which they are already doing, or which that they would plan to do. So yes, mass surveillance is not only alive and well, but governments are finding ways of making that the law of the land.
So my question is, will it be, I mean, it can be necessary and proportionate to have mass surveillance. That's what you're saying.
No, that's not what I'm saying.
No.
What I'm saying is it can be necessary and proportionate to have targeted surveillance.
Yes.
And what I'm saying is there is not yet any evidence which convinces me that it is necessary and proportionate to have mass surveillance.
Excellent. That's what I was trying to. Thank you very much. Now, please, I'd like to put your hands up, please. I can say 1, 2, 3 straight away. I'd like if the gentleman in the middle with glasses, please, first, and then the lady after, and then the gentleman there, please. Your name, please, and your question to all of us.
Hi, I'm Marcel, and I would like 2 copies of your book. One so that I could send to Vinsurf, I work for Google, and the other so that I could read. Thank you.
Thank you.
Excellent. Okay, the lady.
2 sales.
The lady next to him, I think, just yeah. Thank you. Your name, please.
I'm beginning to regret that I don't have royalties on this book. You know, it's just one of those academic projects.
You're not a lady, Chris, please.
No,
Chris.
I was confused, maybe because I was sitting directly behind one, so it looked like a different arm.
Apologies.
Chris Marsden, University of Sussex. Joe, I'm interested in your opinions on, and without being specific, on why it is, given that what's happened in the last 2 years is, as you say, a lot of ex-post legislation designed to legitimize what had been going on to a large extent because of the Snowden leaks, or the Snowden revelations. Why is it that parliamentarians are so extremely compliant? I wouldn't say what are they scared of, but why is it that they are being so extremely helpful? Can we excuse it because of technical ignorance, or the fact that they don't think that, for some reason, they don't think there are votes in privacy? I'm just interested in whether you could speculate a little bit, without being too particular, about why it is that this is being accepted so easily. Because it's only once we know the reason why Parliament's being so compliant that we can get an idea of what lobbying we could do to make the lesser.
Okay, I'll try to speculate as little as possible. But I think, first of all, you have genuine cultural differences here. There is no way that you can say that Parliament is being complacent in Germany. Angela Merkel, one of her stickiest problems at this moment in time is how on earth to handle all the political backlash and pushback that exists because of the ongoing scandals, dare I say, use the word, which arise out of the relationship between the United States and Germany and exchange of data. I have a whole presentation which deals with that. I'm not going to give it to you, but I think it's important that you recognize that at this moment in time, Merkel has had to at least publicly suspend some cooperation with the United States in exchange of intelligence, has had to publicly take a stand where she says that her position in the European data protection reform package is opposite to that of David Cameron, who says it's not business friendly enough, and the Germans say that it doesn't protect enough. And on the UK stance, I think it's a mixture of things, that unlike Germany, which is more sensitive to its past risks, Stasi, so on and so forth, the UK tends to be more trusting. I think the answer comes in several parts, Chris. A more trusting public in the UK, genuine concern about the effects of security, and genuine ignorance in some areas. I am actually surprised by the fact that some questions, some pretty hard questions, have not been asked of the people who are proposing the legislation. And I think that David Anderson in the UK has given a very correct answer, which is, this is what the police and other people want. Now we have to decide whether we want to give it to them. And you can only reason as to why you don't want to give it to them if you can give hard facts and you know what you can get with metadata alone without going for content and interception in an unwarranted way, as is being expected in some cases. I could go on, I won't, but please remind me, because there are a couple of things which I'd rather not go on the record about. but that would be speculation.
Thank you, Joe. We have the gentleman over there, and then we're going to go to Anna and then to Harry, please.
Good afternoon. My name is Gustavo from the Universidade Federal do Rio Grande do Norte, from the research group on internet law. And my question goes to Professor Joseph, and it's about anonymity. The Brazilian Constitution forbids anonymity in the context of the freedom of expression. Still, judges and lawyers and legislators have given many ways, many interpretations to this law that effectively I can go to the internet and express my opinion anonymously. So the law is, well, the law actually permits it. Still, some legislators are trying to effectively forbid anonymity on Brazil, on the internet. You would have to input your name and some of your data to express your opinion. So my question is, what do you have to say to those legislators, both in Brazil and in other countries, who are trying to prohibit anonymity? Thank you.
Joe, before you start, we don't have that much time, so I'd like to come to the panelists as well as yourself for some quick responses, because there's lots of questions in the audience. So if you give me a quick response, and then we go to the panelists, we'll go back to the audience, if that's okay. Thank you.
I'll be as brief as I can. I would very respectfully say that is one part of the Brazilian Constitution which I would recommend be amended. I would very respectfully say that it does not. This thing has died. It must be those politicians, but am I back? Okay, kidding apart. I would very respectfully say that for them to understand how important anonymity is, you have to examine what happens to people when they don't have anonymity. And threat of retribution, fear of retribution, actual retribution at several places, several instances, have persuaded me that anonymity is a very valuable tool, which is why I appreciate the efforts of all those Brazilian judges and lawyers who have somehow found a way to, quite frankly, from a legal point of view, manage to find a case for anonymity where the Constitution would say there is none.
Thank you. Hence encryption and hence the discussion on whistleblowers. Anna, please, then Harry, and then Danny. Thank you.
Okay, I want to just shortly comment on the why are parliaments so obedient thing. And I think, like, at least in Germany, where I'm watching this parliamentary inquiries of the NSA scandal quite close, it's a bit different because we have to really distinguish between the parliament and the chancellery, because we have big differences there, because we have in the parliament those inquiries and the parliamentarians are kind of really pissed that they are really hindered at revealing what really happened, and we have the chancellery which is trying to keep as much in secret as possible, which we really recognize every time we have those inquiries. And I think the reasons why the chancellery is trying to do this are not so secret, or we don't have to guess so much, because in Germany they are kind of the boss agency of the Foreign Secret Service, of the Bundesnachrichtendienst, and they have those cooperation with the NSA, and they did a lot of things which are against the law. And so if they did things that are against the law, it's partly also their fault, and they really don't want this to come out. And another thing is that, like, the German secret services are kind of saying they are depending on the other secret services, like the British ones and the American ones, and we had those quotes from the president of the Foreign Secret Service in Germany that, yeah, without the Brits we are blind, so even if they are spying on us, like, we can't cancel our cooperation and we can't do anything that will make that they are kind of angry with us, and they want to cancel their cooperation, because then we have a problem with that. And that's kind of, I think, causing the obedient nature of, especially in Germany, the chancellery, which is reacting to the NSA scandal, and which isn't only a NSA scandal anymore, because it's like the scandal in Germany with the own secret services is as big as the NSA scandal was before.
I mean, again, I think these things are mostly historical, right? So Britain actually never fully entered the Enlightenment, right? They don't have a constitution. They're still ruled by a queen. It's actually a quite pathetic state of affairs if you think about it. And so essentially, of course, the ruling class of Britain, would like to stay in power. And, given that their empires collapsed, one of the few things they have on the market to everyone else is intelligence on other countries and on their, of course, their own citizens. So I think, you know, they have a very clear case for pushing these laws through. But I don't think Brazil should get, Brazil, the Marco Seville was a good step forward. We all agree, but my question to the audience here, particularly to those studying law, is, you know, in Brazil, the week after Marco Seville was passed, there was a raid on a server, the Savara server, where disk drives were taken due to the minister, I think, of public affairs or federal, I forget the exact name, but essentially there was a server seizure. And why was the server seized? The server was seized because there were activists, actually of a left-wing nature, on the server. And I think what you actually see motivating a lot of the mass surveillance, what makes the parliamentarians so obedient is, of course, the fear that if they don't pass more surveillance laws, they could be blamed and could be considered weak on terrorism. But actually what you see happening on the ground is not, and this is where the UN rapporteur is particularly correct, that these laws in any way, we have very little to no evidence that they actually help prevent terrorism. In fact, you know, good old-fashioned infiltration, which is another thing to talk about, seems to be the only thing that, you know, you could make some arguments for. I wouldn't. But what they are useful for is they're very useful for controlling the population, particularly your internal population, and spying on other countries. And this is a game that every country wants in on, right? The U.S. just has an advantage because all of Silicon Valley is in the United States. And given that there's massive reasons for every country, including Brazil, to basically repress dissidents, and which is funny because, you know, Dilma was, of course, declared a terrorist in her youth. To repress dissidents and call any political enemy terrorist, I think the real question is, how can you patch up these legal frameworks? Even the legal frameworks we saw presented this afternoon had giant holes in them around national security, intelligence agencies, and the police. And these exemptions are big enough for any country to drive an apparatus the size of the NSA through. So to be honest, it seems like a dead end, to me at least, to pursue legal remedies against this situation, which is, of course, why I work on encryption, open standards for encryption, and free and open source software, such as the ones used by Calyx and Rise Up and other people, the LEAP project, in order to enable people to communicate with encryption, regardless of what rights their silly government decides they have or not, or other citizens may not have, because I think these rights, the rights for freedom and privacy, and to exist without surveillance, pre-exist any ridiculous legal enshrining of these rights, and therefore should be preserved regardless of the legal situation. And the only way we know how to preserve these today is currently technical.
Thank you. Danny, please come in on this discussion, I think.
Sure. So I think we've sort of concentrated on the idea of, like, how do we actually achieve sufficient political oversight of these growing mass surveillance infrastructures. And I think one of the key problems right now is that the place that this has grown and the opportunity for this to grow has been as a branch of espionage, has been part of the intelligence services. And the intelligence services, for many, many years since their inception, have really existed in a somewhat lawless location in the nature of society. There's very little rule of law, there's very little oversight, and what oversight there is constrained by the ideas of a secret state, of a classified state. So when we talk to politicians about this, it's kind of interesting because after the Snowden revelations, as I have to officially, that's like one word at this point, the Snowden revelations. After the Snowden revelations, the response we got off the record with politicians whose job it was to oversee the surveillance systems was one of relief, because now they could at least talk to other people about it, right? Now that they could consult with technical experts, and technical experts would sit and say to them, look, these are the consequences of the things that you've been signing off, right? When the surveillance infrastructure comes to you and says, we'd like to collect phone records that are 1, 2, maybe 3 hops away, and it's for national security. It's actually hard to spell out the consequences of those situations. When the great and good of Vint Cerf, and I liked how his picture appeared above my head when you mentioned his name. He always looks kind of sepulchral. But anyway, when the great and good talk and make these fundamental errors about privacy, what you have to understand is that for politicians, they're trying to cope with very, very complicated technical ideas when they're not even allowed to talk to their own staffers about it. So it's very understandable that ultimately that they get captured. And this is what we see in this new range of legislation. The legislation that we're seeing going through in France and in the UK and even in the US really risks being less a regulation and more simply a description of what's going on. So you have this combination of the secret state essentially defining the terms of a very powerful system that isn't just about catching spies anymore, it's being a tool that can be used in any aspect of an open society, culminated with a sort of inertia where this surveillance system has existed for over 15 years without any oversight. So it's very easy for the experts to come in and say, we're only trying to preserve the status quo. One of the things I think is most interesting about the Investigatory Powers Act in the United Kingdom is it defines for the first time the state's ability to hack into individuals' computers and hack into corporate systems to conduct what it describes as bulk machine interference. That's an incredibly broad power, as I think everybody here knows. And the fact that it's now enshrined in law doesn't give me any reassurance. It merely means that we're describing a status quo that we've never conducted the kind of oversight that was needed.
Thank you very much. When I came to this discussion, I was wondering whether we have any hope in this discussion regarding the future. And my hope is not as high as I thought it would be. There's a document called, by the Parliamentary Assembly of the Council of Europe by a Dutch parliamentarian called Peter Omtzigt, which was released in March this year. And it's a very good report. It's very thorough, very interesting, well worth reading. And in the conclusions, he says the following: in sum, nobody and nothing is safe from snooping by our own countries and even foreign intelligence services unless we succeed in generalizing the use of secure technologies. So my question to you, to all of you, is that is there a silver bullet or not? Is it a panoply of different things that need to be done? A review of the law will take quite a long time, won't it? I guess it will take some time, and it won't be done in all countries at the same time. There's questions of protecting whistleblowers, encryption. Where does the hope lie for responding to these issues, for this legitimization through law or draft law for mass surveillance or targeted surveillance? I don't know. My question is open to you. Maybe we go to the audience. Do you have any responses to that or to other questions you'd like to put back to the panel? We have more time than in fact, the good news is for those of you who are able to stop over, we can go over time, I understand, by a little while, so we're not strictly bound to 6 o'clock, which is in 12 minutes. So anybody, please tell me what your thoughts are. It's for you. This is a panel. This is a discussion for you. It shouldn't be a one-way discussion.
But Lee, you are asking them to solve this problem. They might be a bit quiet.
Yes. Well, tell me, is there hope in this room?
Well, I mean, okay, go for it.
Marilia, and then Harry, please.
Thank you, Lee. I like it very much, your speech, Harry. I just think that there is no dichotomy really between using technical solutions to protect your privacy and fighting for better laws. I think these are just two different playing fields. If you don't fight for I think that there is room for civil disobedience, and adopting encryption when encryption is not allowed is telling the laws and the lawmakers that they should change the law in order to allow yourself to protect your privacy. But at the same time, I think that if we say that this is the only solution, first of all, you're just taking out the responsibility of the states to create better laws, and I will protect myself, and just think that different people, they don't have the same level of technical expertise in order to use encryptions or even to know the importance of encryption. Just think about so many people in the developing world that are thinking about having any access at all, and that are accepting internet.org because they don't have another opportunity to have access to anything. So if you think about these different realities, I just think that if we say this is either or, it's dangerous to go this path. So I think that there are different playing fields to fight for technical solutions and better laws as well. And just a quick question to Joe. You mentioned the importance of concrete data and research for the process of not only developing better laws, but also for the work that you're doing. In your opinion, what would be right now the key necessities that you and other people working in the UN and working with privacy would have in terms of research? Is it more research on jurisdiction or differences between jurisdiction? Is it more research on technical aspects? What would help you with your work in terms of research and academic work? Thank you.
Do we want to go to Harry or Joe? We'll go for Joe first. Joe first and Harry, please. Thank you.
Okay, thank you. And thank you for that, Maria. Actually, it leads me to say that I think that encryption and legal and procedural improvements really can go hand in hand. And in fact, I actually think that encryption is one of the key tools which will bring governments to the table. Because as somebody said, what has happened so far is that governments have been operating in a fairly lawless place. So basically they could get away with it. And we have 15 governments which have been more active than the rest, and they've gotten away with it. And so the more encryption you put on there, the more they're going to realize that this may not be the way to go. Also, I should say that it's in some cases it may be civil disobedience, but in others it would be perfectly legal. It would be perfectly legal to use encryption. Thirdly, governments are slowly realizing that however many obstacles they may put up for encryption, there is no way they can contain encryption globally. Not for the bad guys, not for the good guys, which is one of the reasons why I believe that some governments will eventually see sense about encryption and privacy. To come back specifically to your question, Maria, what we need at this moment in time are two or three things. One, documentation of new laws and new initiatives which are being introduced. Some of this is already done by Privacy International, Human Rights Watch, etc. But there's never enough, right? And even though we have a bunch of people in the Netherlands and others in Malta, in the end, the United Nations is only going to give me 3 staff members. And I'm considered to be lucky to have 3 staff members. So when we're putting together the data, the hard evidence of what is going on, we need to know infringements, we need to know loopholes in the law, we need to know technical safeguards, we need to know also the differences between countries, also in order to help persuade them to come to the table. Because in the end, in a lot of this, as I'll be saying tomorrow, the day after, we do need to refresh some of our legislation. By that I mean we need to look at current existing legal instruments and improve them and increase our understanding of what privacy is internationally, and also at the same time bring in some new legal instruments which will help provide the common understanding. I have, and this is the second time I'll say this today, in an internet without borders, what I'm advocating is safeguards without borders and remedies across borders. And I think that these are the key things we should be aiming at. In order to achieve that, the only way you can do that at international law is through a treaty. Other than that, all the bilateral things we can do can help. Bilateral, multilateral at regional level, like European level, can help, but it's not enough. And I would like to conclude by saying, I think there is no one silver bullet, but if you take a combination of measures, including technical measures, including encryption, if you take legal measures, including new laws, if you take operational measures, and if you take especially oversight. The question of oversight has not been delved into, and we haven't had the time to go into it enough at this moment in time. But by oversight, I mean real oversight. I don't, at this moment in time, in a number of countries, oversight of the secret services and of law enforcement to a lesser extent, but especially because of the way that secret services have historically developed, what has happened is that oversight tends to be pretty weak and often restricted to just to judicial oversight or oversight of a paper trail. And what I'm saying is that in any democratic society worthy of the name, oversight should be much more than oversight of a paper trail. You should have the abilities of an independent oversight authority which has 2 or 3 key things, including 1, the technical ability to carry out technical spot checks, probing the software that is being used, probing the methods, and obviously, although it carries some risks, a contingent of poachers termed gamekeepers. It's only by knowing intelligence craft and police craft that you can, it takes a thief to catch a thief. You have to know the way that things are done. One of the problems, my friends in the German Secret Service, for example, when I asked them what are the oversight mechanisms which they find problematic, they answer that the problem is that even when politicians come along to speak to them, as they do sometimes, they don't know enough about the subject. They don't know enough about the trade and the craft. And so the lawyers on the side of the secret services are often at a loss on how to handle the situation properly. So what I'm advocating here is also the building of bridges, the correct bridges with the secret services. And I'm not saying that there are some secret services that don't have nothing to hide. That's not what I'm saying. What I'm saying is that the oversight mechanisms we have at this moment in time are imperfect. They need to be improved in most of the countries I know. In fact, I don't know one single country which has a perfect oversight mechanism. All I know is that some oversight mechanisms are worse than others. Thank you.
Thank you very much. Harry, do you want to come in on this?
Yeah, so I actually, just a quick comment. So actually I do have a lot of hope, just not in the legal apparatus right now. So we've seen over the last year or two, we've seen a number of initiatives, some from IGF, many from industry, and many from the grassroots, from hackers and other developers, to basically enable easier to use privacy-enhancing technologies and to increase the strength of encryption everywhere and deploy it en masse, so that previously, while only a very small percentage of internet traffic was encrypted, we're seeing vast gains in that being done, and those are being done primarily by increasing the amount of encryption deployed in open standards like those we created, W3C and IGF, which are done in an open process, so we know they're not being subverted, and implemented with open source code, so we know there's not a backdoor and we can check the code. That's really important, and we're seeing vast gains being made there. And in fact, if I were a government and I was looking for an economic model for how I could succeed in the 21st century, rather than being some sort of, rather than having to deal with this sort of new generation of cyber colonialism and cyber espionage, which is actually what we're seeing develop now. If I were, say, in Brazil or in Africa or anywhere else, I would be actually encouraging the use of encryption. It's the only way you can defend yourself, really, against hostile intelligence powers. And that this actually could be a giant way for countries to gain self-sovereignty and self-determination again, in an era where they're rapidly losing it to this massive sort of NSA-style global secret state apparatus. You, as a small country, will never, ever repeat the success that the United States has in doing this, and the Five Eyes in general, but you can fight back. And I think the technical solutions are quite key there. However, I do think that the long-term solution will not be purely technical. The long-term solution will probably require replacing the current policymakers who do not understand technology or who are frankly cowardly in front of national security and quote-unquote terrorist threats, when we all know the real threats facing the global order are actually global climate change, a current economic crisis, real threats, not threats we use to scare children and justify mass surveillance. If we have another generation of policymakers emerge and get rid of the current ones, and these policymakers actually understand technology, can make laws which are in harmony with technology, and as Snowden put it, inscribe fundamental rights into the protocols themselves and get mass deployment for this, I think we could have a lot of hope. But right now, we're still waiting for this generation to emerge.
Yeah, so until code becomes law. Anna and Danny, do you want to come in on this? Respond?
One short comment.
Please.
Like, I have not so much hope like for the legislators at the moment, because I think like what we see is that, like you already said, we have like bad practices in secret services, and everything that's done is to legitimize them, like to make them legal again. But like I have one kind of hope that's in litigation, because we see more often that people are suing government and people are making things that laws have to be changed. Like we got rid of the data retention directive on the European level. That doesn't mean that we didn't get like the data retention in Germany afterwards, but it's like a signal that you can reach something by going to the court and say like that is not applying according to fundamental rights. And we had this also with the safe harbor ruling of the European Court of Justice, and this is kind of sending out a signal that like a normal person, which is like Max Schrems, a student of law, can go to the European Court, not to the European Court of Justice, but to a court, and then like make this decision ruled invalid. And that's kind of a hope I have, that this serves as an example for more people to follow.
Thank you, Matt. Danny, do you want to come in, Max?
Yeah, so from an organization that does all of these things, so we try and build technology like Let's Encrypt, which will hopefully increase the percentage of encrypted traffic over the internet by tens of percent. And of course, we've conducted litigation for over 15 years to try and rein back many of these practices. I'm sort of in support of all of those things. But there is one other, I think, important aspect to this, right, which is that, I mean, we totally support the right of technologists to encrypt and create new technologies which challenges and pushes back this kind of pervasive surveillance, but we don't want them to go to jail for it. And that's why it's important to try and reestablish the norms, to try and take the fact that we have pre-existing human rights standards which have something to say about the nature of mass surveillance, that it is unnecessary and disproportionate in the way we see it right now, and that those human rights principles should apply even to a new situation that is developed after they were first described. So, we and a bunch of other civil society groups here formulated a set of principles, the necessary and proportionate principles, to try and show how human rights actually apply in the nature of communication surveillance. And what I think many of us see as the important part of this, because it is an international problem, is to try and re-establish this idea, which we're seeing triggered in the CJEU decisions and elsewhere, that from an outside point of view, examining this in terms of human rights, what we're seeing here is a violation, and it does have to be reined back within the existing international legal norms.
We have comments from the floor. We have Marcel, and then we have Luca Belli. Excuse me, do you want to give the... And anybody else for that matter? Okay, three at the back. Okay, thank you. Maybe we take a couple of questions.
Yeah, perfect. It's Marcel again. It's more a comment than a question, and it's about your question. Is there some light at the end of the tunnel? Is there some hope? And I would like to make a political argument here. So I'm very much in favor of all the technical instruments and solutions, and I believe that's one part of the solution. But I want the argument that politicians, that governments are about to lose credibility in what they do. And there are two perspectives here. One is that they, on the one hand, do internally think that they wouldn't like to do externally. So we have states applying data retention. On the one hand, like Germany has done twice now, and at the same time, at the UN level, is supporting the right to privacy resolution. So they're about to lose credibility here. That's one thing. And the other thing is about foreign policy. I mean, we have witnessed over the last 2 years since the beginning of the Snowden revelations, head of states and governments excusing for what their intelligence agencies do. I mean, we have seen that with Barack Obama, with the phone tapping of Angela Merkel and other head of states. We have seen that with Angela Merkel again, so they're not better than the Americans. So they're about to lose credibility about their foreign policy because they have allowed that the instruments of intelligence services has shifted, has been transformed into actors of foreign policy. And that brings them in a very difficult role because they are not longer they are not longer able to control these instruments because they have become actors. So they are losing credibility on foreign policy base. And I think that would be one major incentive for governments to regain oversight and control over the agencies and therefore to restrict the way they work. Thanks.
Luca Belli behind you, please. And Luca, if you can be brief, we have three lovely ladies at the back who wanted to take us.
I don't want to impede the lovely ladies to speak. So the quick observation. So over the past 15 years, there has been an increase in data collection, and that increase started after the Patriot Act was actually adopted in the US. So my observation is that there is a coincidence between the private sector interest of collecting the highest number of data and surveillance and law enforcement agency to also have the private sector collecting the highest number of data. So it's a win-win solution for both government and private sector to collect the more data possible. And in a scenario of Internet of Things, where now there are currently 25 billion connected objects, the number will double in a couple of years. And also, if you have all these objects transmitting traffic, internet traffic, which is encrypted, wouldn't it be simply easy for both government and, let's say, telecom operators to slow down all the encrypted traffic in order to discourage the adoption of encryption? And so to avoid such a scenario, which is actually in countries where there is no net neutrality law that prohibits discrimination, is something very easy to do. So how would you avoid the scenario in which encryption is simply discouraged by throttling down all the encrypted traffic? And politically speaking, what would be an interesting strategy to avoid such a scenario?
Let me just come back to the panel very quickly. Is that a realistic possibility, or
it's not only realistic, it happens already. I mean, so you have states like Iran that will deliberately slow down HTTPS traffic, and also just for economic reasons, you see the same thing happen with virtual private networks. That there will be bandwidth constraints on your phone or something like that, so you'll use a VPN to protect your communications. So it's unclear to the service provider what you're doing, so they just squelch all of those things. The solution to that is pervasive encryption. One of the biggest things that prevents any state from doing that is the fact that now Google is encrypted. Now, as Joe pointed out, Google's encrypted, Facebook is encrypted, Yahoo, an increasing number of major destinations on the net are. So the more people who use encryption and more embedded it is in the protocols, it becomes much harder, not only just to limit people's use of private communication methods that encryption enables, but also to be able to discriminate between different services. It's another way in which encryption can help protect other state initiatives like net neutrality.
So can I just make a comment here? So I do agree that the increased deployment of encryption by large actors such as Google is good. But the fact of the matter, there is a real legal problem, particularly in the United States, I think we should pay attention to, which threatens the use of all encryption and all possible technical remedies and technical defense of human rights. And this is the problem of national security letters or secret court orders, which exist in many countries. I have a paper, I'll be distributing it during the IGF, written with Nick Merrill, who was the only American who fought in court against national security letters and got them ruled unconstitutional, about not on a national level. The way national security letters work in any general secret court order is they sort of say, well, okay, you can be encrypted as much as you want, but we're going to give you an order, and you can't talk about it. You can't even talk originally to a lawyer about it. And you definitely can't tell your users about it. You as Google or you as a small provider, a small business, such as Nick Merrill's Alex Institute, you're going to have to basically hand over your key material so that we can get all the data from your users, regardless of whether you encrypt it to the server or not, or you even encrypt it at rest. As long as you have the key material, then you have to give us so we can take that data, and then you essentially have a gag order not to talk about it. So I think there's two solutions here, and I'd like to ask if people what they think of them, because I think these are important, not just for Internet of Things, but just for really simple things like checking your email. The first is that there's a real difference between encryption and end-to-end encryption. Under end-to-end encryption, the only people who can read the email are those who have the private key material and are thus authenticated in order to read it, not a server or man in the middle, a service provider such as Google or anyone else. I think that's quite important. And the second thing is, how do you defend against a secret court order? Because by definition, you can't talk about them, right? And and the real question we don't know the legal answer to yet, even in the United States, is can the United States government, via a secret court order, force you to lie? So they can say don't talk about it, but can they force you to lie about a secret court order? So we've developed a tool. It's called CanaryWatch.org, developed by Rise Up and Nick Merrill and many other people, which basically says every month they post a statement saying we have not received a secret court order for any of our users. And the question is, the 1 month that someone doesn't post that, then you assume that it's a canary in the gold mine, as we say in English, and that a secret court order has been received. And we don't know what's in these court orders yet. They get revealed, hopefully, if Nick's case goes through, on November 27th. But we assume it's for most of their data. So even as we see encryption spreading, and if we see more and more adoption of it, unless you really can prevent these sort of legal loopholes that force people to hand over key material, then you're screwed. And I would say that the first jurisdiction that actually makes it legal to use end-to-end encryption does not have giant loopholes around anti-terrorism or other ridiculous things. That jurisdiction could have a lot of economic gains that could make. And I think that's where I see a lot of hope. That if I were anywhere in South America, Africa, anywhere else, I really wanted to make a play for the future, that's the play I'd make.
Excellent, thank you very much. Now, we have three ladies at the back who put their hands up. Do you have the microphone? You have the mic, please. Your name and your question, please.
Hi, my name is Alex. I work for Privacy International, a UK-based charity. Just to respond to questions earlier about hope, because that's when I first put up my hand. There's definitely hope. I mean, we just celebrated our 25 years, and there's still definitely a long way to go. I think I don't think civil society, for example, has ever been in a place that it is right now. The information, the capacity it has to do research, to do litigation, but the problem still lies is where the playing field in which we're at. We feel, I mean, at the moment we're suing the UK government every other month, and that's the only way we're getting information, and it shouldn't be that way. That information that should already be publicly available because it is in the public interest should not be the result of NGOs using their funds to sue a government. I mean, there's definitely something wrong with that approach. And that's one of the things that we need to keep working on, to call for the transparency. I know it's been an issue that we've talked about today, the lack of transparency about what governments are doing, because I feel like sometimes we're a bit 2 steps behind, because once we legislate on one and we've won one fight, they actually come out and say, actually, we're doing something quite different, and they show that they have different capabilities. And so that's where the discourse and the work that we're trying to do is a bit counterproductive, because they're not being transparent as to what they're doing. And so the fight that we're fighting is always a little bit behind it. We need to be actually a step ahead. So that will be the next fight that we're going to continue to do.
Thank you very much. I'm just wondering, actually, as you pass the microphone to the next, to Zhang Hong, I think it is. Before you speak, I just wonder about data protection supervisory authorities and their role in this, and are they effective in this fight that you're talking about? Do they need to do more? Are they doing enough, etc.? Because they exist in more countries, at least in Council of Europe countries. But on that point, Zheng Hong, please.
Thank you, Li. This is Xian Hong from UNESCO. I was just at another session on digital ranking ranking digital rights, I was quite surprised to see the results that mostly all the internet companies, they don't well respect either free expression or privacy. So not only privacy was in danger. And as everybody's talking about the law, legislation, policy making governments, I don't think it's sufficient, because what to what extent these companies are at stake in terms of the data protection, surveillance, and what can we do to really hold the company to responsible, to respect privacy? Thank you.
And maybe we take the last question that from the lady next to you. I don't know. I saw 3 hands. Oh, they left. Okay, fine. Okay. Does anybody want to respond to Zhang Hong's question from the panel?
I think it's very important. It's interesting that we've talked a lot about state surveillance on this panel, but we haven't really talked about the corporate surveillance that often enables or works in partnership with that. And it's definitely one of the components that's a challenge. You know, we deal with very poor incentives for preventing states from conducting mass surveillance because they're in a competitive war with other states that they perceive would use these tools even if they did not. And perhaps we're in the same relationship with companies too. And Joe pointed out that many companies are beginning now to use privacy as an argument for why you should choose those services as opposed to others. I think it's a bit of a tragedy in the last sort of 10 years that the decentralized internet has sort of clumped together in these ways and created a few major companies whose privacy policies in terms of service and behavior we in some way depend on for the exercise of our rights. But I'd also just point to Privacy International's work in tackling both of those parts and does the same kind of technical knowledge, litigation, and painting a map, an international map of the links between companies' attitudes to privacy and the effective use by states in that.
But Danny, just let me ask you: they do, companies do transparency reporting, but does these questions come up in their report, or are they missing? Normally, it's notice and take down and these things. Does this come? You find that? Well, I don't know many transparency reports.
So totally. I mean, we can widen this out, but in fact, one of the reasons we sort of initially nudged these companies to do transparency reports is to reveal state requests. Now, what's interesting about it is, as Harry pointed out, one of the things we knew that they couldn't talk about were the secret requests, which in the United States, it's national security letters. In China, it's actually a violation of national security law to even disclose that this sort of stuff is going on. What's interesting is the sort of strange incremental pressure you can make in small areas. So now, and it seems like such a small improvement, but now you see in these transparency reports that they can describe canary-like the range of numbers of national security letters. So they'll say, we have received between 0 and 99 national security letters. And so that paints some of a picture of these things. But I think they're much more comfortable talking, at least internet companies are much more comfortable talking about pressure from governments because they feel that they can take some sort of stance on that. I think they're much more uncomfortable describing their own sort of internal privacy mechanisms or not.
Well, there's still reports which are done by the company for the company, whatever information they give to it. So the question of objectivity in that process is something to discuss maybe later. Anna, do you want to come in because Joe wants to come in? Anna first, then Joe maybe. Is that okay? Anna, thank you.
Okay, we've been talking, there is a lot of discussion about making privacy a market advantage, but I have one problem with this because even if it's kind of a market advantage, we have to give the user an educated choice, and that's not the case at the moment. I think that's something where we can do a lot even without some laws for doing that, for giving people an overview what terms of service actually means. That the Ranking Digital Rights project is trying to do that, but one of my biggest criticism on the project is that I mainly use things from open source, from the terms of services the companies actually publish, and we have to give new opportunities to assess how privacy-friendly a service is, and that we can't do when we only have one service, like when we only have like Google or Facebook or things people are choosing. And I think there is the opportunity for like smaller decentralized services to get into the market with privacy-friendly solutions. Like we have one really small email provider in Germany which kind of exploded after the Snowden revelations because so many people were choosing it. But then also the problem is if this one is getting too big and there are no other choices on the market, then it's also a problem again. And so we have to really educate people about it and give them alternatives and not like stick with the old choices and analyze like the privacy terms of Google and rate them because we want to get away from this monopoly.
Thank you. Joe, before we just a second before we turn to Joe, I'd like the person to queue up the video clip. Harry, you've got, but Joe's first and then the clip. If
I'll
that's
just
okay.
do a quick intro for it.
After Joe, please. Joe, thank you.
Yes, thank you. I'd just like to come in on this very delicate issue of corporate and where we're going. I tend to be optimistic, not because I have the happiness gene, but because I agree with Alex from Privacy International that actually privacy has never had it so good, in the sense that things have improved enormously in terms of resources and awareness in relative terms. That doesn't mean we don't have huge problems and huge issues to deal with. However, for some years now, some people have been talking about the modern equivalent of what in Eisenhower's days was called the industrial military complex. And that it's pretty cozy for both politicians and corporations to have such an interest in personal data. Yes, possibly, but there seem to be some indicators that since money makes the world go round, and since there could be considerable commercial advantage from marketing yourself as privacy friendly, then actually I think we could be in for some very interesting times, and I'll stop by describing those times. On the one hand, at this moment in time, I dare say that many companies, at least those that I know, would sincerely drive for a way where they don't have to give data to the government. That being said, if you then turn to them and say, okay, so you are for reforming government surveillance laws, but what about your own practices? Do you think your own practices in profiling people are disproportionate? That is when I think they're going to start to get pretty itchy. And to tell you the truth, the job of privacy rapporteur is actually to tackle both subjects. And I don't know, as one of my old law professors used to say, pleasure's yet to come. Thank you.
Thank you, Joe.
I'd like to just introduce, so I'm here on behalf of Calix Institute and Nick Merrill, who fought these national security letters. And I would say what you can do if you're concerned about corporate surveillance is don't use the large corporate servers if possible. Instead, support local open source based providers who will do things that no major company will do. In other words, they will defend your privacy, till the end. And I would like just to say that we do have cases of this. Nick was one of the few people, despite all of the money that Google has, they didn't fight the NSLs, really. While a single person running a small internet provider in New York City took it up as far as he could over 10 years. And I think that we need more people like that, more companies like that, who are willing to put it on the line. And then we need lawyers, hopefully some of you guys, and government officials to support these companies and not let them be crushed by the oversight, the overreach, but also, I guess, the oversight of the intelligence agency. So I'd just like to introduce Nick real quick.
Okay, keep the video, please.
I don't know if you can hear it, though.
Who's playing it? Okay.
Greetings to the Internet Governance Forum. Thank you very much for giving me a platform to speak to you today. Thank you also to the Web and Law Foundation for their generous support. My name is Nicholas Mann, and I would like to talk to you for a few minutes about problems with secret orders for data. From 1994 until 2011, did so thanks to the pro bono legal assistance of the American Civil Liberties Union for 7 years, and most recently with the pro bono legal help of Yale Law School. It turns out that I was the first person to challenge constitutionality and legality of the National Security Letter program, which originally USA Patriot Act proposed September 11, 2001. Metadata, which is the type of data that typically can be seized with a national security letter, really means records about your private activities and associations. It's essentially an activity dossier. The novelty is in the lack of awareness. Because national security letters come with a never-ending gag order, the recipients of the letters never speak about having received them unless they fight the gag orders in court. But the vast majority of them do not, either because they lack the resources or they lack standing in other places of employment to be able to use them. The never-ending gag orders on the recipients of the letters means that public debate on the use of investigative techniques like NSLs can't happen, and that results in basically a total lack of transparency. Due to the secrecy of the subjects of the orders, targets of the orders, also never get a chance to assert their rights or ever find out that their data has been seized. How can we possibly evaluate the efficacy of these law enforcement techniques when they're secret forever? Through my case, my legal case, the national security letters were ruled unconstitutional twice, in 2004 and 2007. But since the case never made it to the Supreme Court, those decisions didn't really have any effect. In fact, the U.S. government is still using national security letters today. National security letters supposedly are only to be used in cases of terrorism or counter-terrorism. However, one of the outcomes of my case was that the Department of Justice performed an audit of the FBI's use of national security letters. They found that almost 300,000 civilizations over just a 3-year period, which is roughly one national security letter per 1,000 Americans. It makes me wonder if there really could be that many terrorism or counter-espionage suspects. I've since become convinced that one of the best ways to deal with this problem is to deal with it from the network side and the design. Perhaps it's because that's the business of academia, is building networks, but what I'm working on with my latest venture, which is a non-profit organization called Intelligence is trying to design telecom services so that the service providers themselves do not have access to either the communications content or another data. Thank you.
Thank you, Nick. Okay. Oh, echo. Okay. So it's 18:29. I think we are now going to conclude by. Well, I will conclude, if I may, unless there's some burning things in the room, to say thank you very much to our dear panelists and to the UN Special Rapporteur. Thank you very much to you for coming. Great interventions. And to you, to the audience, for coming in and making it a meaningful discussion. The fact that you stayed here until 18:30 is proof that you really liked that discussion. You didn't leave the room.
Yes.
Sorry?
You can't get out, maybe.
You can't get. Oh,
No,
the door. Actually, the door is locked. Thank you. Maybe the door is locked. But on that, thank you very much, and I hope to see you each other again later in the week.